Hello viewers, today we are going to do section 284 regarding removal of directors. This is chapter 6 of the company law portion. Section 284 deals with the removal of directors in certain situations. However, this section does not apply to the following directors who have been appointed. Number 1, the director who has been appointed by the central government under section 408. Now, section 408 deals with directors appointed because of oppression and mismanagement in the company. Secondly, it is the directors who have been appointed by the IDRA, that is Industrial Development Regulation Act. Thirdly, the directors which have been appointed under SICA, that is Sikh Industrial Companies Act. Fourth, a director of a private company holding office for life on 1/4/1952. That is, all those directors who have been appointed after 1st April 1952 for a life term, then they also cannot be removed by section 284. Fifthly, the directors who have been elected by the principle of proportional representation under section 265. According to proportional representation under section 265, the directors could be appointed by either single transferable vote or by accumulating voting system. Now, when these directors have been appointed under such a system, they hold office for the term of 3 years and hence they cannot be removed under section 284. Sixthly, the directors who have been appointed by the company law board under section 402. When the company law board has appointed the directors under its directions, then those directors could also not be removed under section 284. And then the nominee directors. The nominee directors are those directors who have been appointed by the public financial institution to see about the usage of the loan which is being done by the company in case it has taken a loan from the public financial institution for its expansion and growth. Now, the procedure for removal of director under section 284 shall be first to send a notice regarding the removal to all the members. Such a notice or such a application could also be sent by any member for the removal of the director much before its term. It is noteworthy to remind that a director shall be holding the office from one AGM to the other AGM, but between this time period, a director could also be removed much before the expiry of this term of 1 year. In case this has to be done, then a special notice of 14 days has to be sent to the company before conducting of the meeting. A special notice means a notice of 14 days before the entitled general meeting for the removal of the director. Now, on the receipt of such a notice, the company shall forthwith send on a copy to director to enable him to make a representation. This is done so that the director can also reply to the allegation or reasons that have been put on the notice for his removal. So, an opportunity to be heard is given to a director before the removal of the director is done. If the director has made a representation in reply to the notice in writing, then he can request the company to notify all the members and direct that the representation be sent along with the notice of the meeting to all the members. If the representation is received well in time, then such a notice could be sent with the notice of the meeting, and the fact that the representation has been made shall also be sent along with the notice of meeting. In case the notice is not received on time, then such a notice shall be read at the meeting in which the removal of the director is being done. The removal of the director shall be done by way of a resolution and not otherwise. When the notice has been sent to the members and the members are present at the meeting, a resolution shall be passed. When the resolution is passed by the required majority by way of ordinary resolution, then the director's removal will occur. In case the representation of the director is not received by the members on time, that is 14 days before the date of meeting, then it can be read at the meeting. The director also has got the right to be heard at the meeting by reading out the representation or by making a representation in person, subject to the restriction that he shall not make a representation to acquire needless publicity regarding a defamatory matter. That is, a director will not be allowed to speak at the meeting in case he is trying to get publicity for some defamatory matter against the company. In such a case, only the representation shall be circulated and he will not be talking at the meeting at all. This power has been given to the CLB to prohibit such a representation on receipt of application from the aggrieved parties. And another director could be appointed either at the same meeting or at a subsequent meeting. But if another director has to be appointed at the same meeting in which the removal of the director is being occurred, then the notice of the same should also have been sent to the members. Now, the notice again will be a special notice, that is 14 days notice regarding the appointment of another director at the same meeting. Otherwise, another meeting could be conducted. Now, such appointed director shall be holding the office in place of the director being removed only up to the period of his predecessor. If 3 months were remaining in his tenure of the director who has been removed, then he shall be holding the office only for 3 months, and if there is a date of AGM which is coming in between, then such a director who has been appointed could be reappointed. That option is available at the AGM. Such a vacancy can also be filled as a casual vacancy under section 262. That means even the board of directors have got the power to fill it up as a casual vacancy under section 262. Now, we shall do the general powers of the board under section 291. The general powers of the board do not name single powers which can be exercised, but they are like an umbrella or a blanket guidelines of what the board can do. Number 1, the board shall be entitled to exercise all such powers and to do all such acts as the company is authorized to do. The board shall not exercise any power or do any act which is to be exercised or done by the company in general meeting. This means that the board shall be doing the regular day-to-day work which regards the management of the company, but it shall not do all those acts which require the sanction of the members and the company in the general meeting, for which a general meeting, that is extraordinary general meeting or annual general meeting, is required. Thirdly, the board of directors' action or power should not be inconsistent with the following. That means the board can do all those acts which are not inconsistent or in contradiction with the Companies Act or any other act. Secondly, the memorandum or articles of the company. Thirdly, any regulation made in general meeting or otherwise. The company in general meeting cannot by regulation invalidate the prior acts of the board which would have been valid if that regulation had not been made. So, if an act has already been put into practice and the board has decided over that act, it cannot be invalidated by a general meeting if the board is otherwise entitled to do. Now, there are certain powers which are exercisable by the board only at the meeting. So, these powers can be exercised by the board without even a sanction of company, and they will be done at the board meeting itself. The section 292 explains that the board in its board meeting can make calls on shareholder in respect of the money unpaid on their shares. Secondly, to authorize the buyback under section 77A, to issue the debentures, to borrow monies otherwise than on the debentures, to invest the funds of the company, and to make loans. In respect of the last three powers, that is to borrow money, to invest the funds, and to make loans, these powers can be delegated either to the managing director, the manager, or a committee of the board, or any other principal officer of the branch. The board should pass a resolution for such declaration in case all these three powers are being delegated to the managing director, manager, committee, or any other principal officer of the company. The resolution which delegates the powers should contain the extent of authority which has been granted to the delegate. That is, a sanction of, say, make a loan of 50 lakhs, if it is being given, then that 50 lakhs should be specified to what extent the loan can be given, to what extent the borrowings could be done by the managing director, because then this marks the powers of the board up till which it can be exercised, and anything which is beyond the power would be considered as ultra vires acts, and hence it will not be allowed by the company. In the point number 3, that is to borrow the money, it will exclude the borrowings by a banking company from other banking companies, or from Reserve Bank of India or State Bank of India or the other banks. So, the mutual borrowing between banks shall be excluded in the term borrowings. With respect to the overdraft and cash credit, the arrangement made by the company with its bankers is to be considered and not on the day-to-day operation. So, the OD and CC limit will be taken into consideration and not the day-to-day operations. However, the above powers can be restricted by the company at the general meeting. Now, there are some restrictions on the powers of the board which are being given under section 293. The board of a public company cannot, without the consent of the company in general meeting, do the following. That is, number 1, sell, lease or otherwise dispose of the company's undertaking or substantial part of the undertaking. Selling of the company, leasing it or otherwise disposing it of affects the liability and affects the stake of the shareholders. Hence, all these major decisions cannot be taken by the board itself without the sanction of the company, that is the members of the company. Secondly, limit or give time for the repayment of any debt which is due by a directors. If any debt has been given by the company, then one could not extend the time without the sanction of the members, because again it affects the liability of the company, because if more time is given, it might turn out to be a bad debt. So, one should see what is in the favor of the company, and these major decisions should only be taken by the members. But this will exclude renewal or continuance of an advance which has been made by a banking company to its director in the ordinary course of business. Thirdly, invest the amount received on disposal of undertaking otherwise than in trust security. Investing the amount which has been received, which means if any major amount is received from the disposal of the undertaking, selling a part of it, selling a unit of it, then that amount should be invested properly otherwise than in the trust securities. Then is the fourth one, borrowing monies, where money is to be borrowed together with the monies already borrowed will exceed the aggregate of the paid up capital and free reserve. Here the temporary transactions from bankers in the ordinary course of business shall be ignored. When the borrowings are increased, it should be seen that the paid up capital plus free reserves portion should not be exceeded, because this increases the riskiness of the company and it becomes trading on equity. So, one should not borrow in excess of the total paid up capital, which is represented by the assets and the free reserves. Then the fifth one, that is contributing to charitable or other funds which are not directly related to the business of the company or the welfare of its employees, any amounts the aggregate of which will exceed rupees 50,000 or 5% of its average net profits according to section 349 and 350 during the immediately preceding 3 financial year, whichever is greater. This means that a company cannot contribute to funds which are not in consonance with the objects of the company. Supposing a company is dealing with education, it is involved in educational promotion or educational tools, and it contributes in a metallizing charitable institution which deals with giving education to regarding how to make tools, etc. Then this is not in consonance with the objects of education, though it can contribute for anything done for the benefit of its workers. So, the ceiling which has been put for such contribution is rupees 50,000 maximum, or a 5% of the average of net profit of the preceding 3 years. Now, with respect to the points 4th and 5th which we had discussed earlier, where a resolution is passed at the general meeting authorizing the board to borrow or contribute, such resolution should contain the extent of authority which has been granted to the board. So, all the powers which have to be exercised by the board should have at least a limit or the area or the extent or the limit to which they have been given the power. Now, regarding the loans which could be given, the temporary loans shall include the loans which are repayable on demand, the loans which are repayable within 6 months, that is cash credit, bill discounting, etc. Then other short term loans of the seasonal character. The temporary loan terms shall exclude the loans which have been raised for the purpose of financing expenditure of the capital nature. The company should not reduce its capital due to sale, lease or otherwise of an undertaking or part of an undertaking, because when it reduces its capital due to sale or lease, the security for the loans also reduces, because the same loan is represented by the assets. So, when the assets etc. are lost, then the security also of the creditor goes away. Where the company has borrowed in excess of the limits which have been specified in the 4th point regarding paid up share capital and free reserves, then the tender cannot demand repayment unless he has proved that he had advanced the loan in good faith and without the knowledge that the limit had been exceeded. Now, this is done in consonance with the principle of ultra vires, in which if any borrowing has been done by any person which is ultra vires the company, then he cannot claim it back unless he proves that it was bona fide without his knowledge and done in good faith. Now, let us do the section 299 which deals with the disclosure of interests by the director. This section applies to all the directors of a company who is in any way directly or indirectly concerned or interested in a contract or arrangement or proposed contract or arrangement or to be entered into by the company or on behalf of the company. He should disclose the nature of his concern, interest at the board meeting. This section applies so that the directors who are interested in a particular resolution, if they disclose the interest, then they have to abstain from voting on such a resolution. This is required so that a fair amount of decision can be taken rather than partiality and rather than the director who is interested in a resolution voting at it. Now, such a disclosure should be made at the first board meeting, which is held after the director becomes concerned or interested. Now, such an interest could be if any contract is being given to his relative, or if he has a financial interest in such a contract. So, such a disclosure, if it is made on time, then he can abstain from voting and the fair resolution could be passed. Thirdly, where a contract or arrangement is proposed, disclosure should be made at the board meeting at which the contract arrangement was entered into and taken for consideration, or at the first board meeting held after he becomes interested, concerned, in case he was not interested at the time of entering the contract. Here three kinds of dates have been given. If a director becomes interested and that subject matter is being taken at the first board meeting to be held, then disclosure can be made at such a first board meeting. Secondly, if the board meeting is conducted and he is discovered to be interested, then he can make the disclosure at that board meeting itself. And thirdly, if that contract or resolution has already been adopted and he later on becomes interested, the next board meeting he can make the disclosure because he has already become interested in that particular contract or a resolution. The disclosure can be made by giving a general notice to the board. Now, such a notice can be given in writing to the board, telling about the kind of interest that he has in that particular resolution or contract. Thus, the notice shall have effect during the financial year in which it is given. So, he has to give the notice only once in the whole year. Such a notice can be renewed for one more financial year by giving a fresh notice in the last month of the financial year before the expiry. So, say for example, the financial year of the company is April to March, then if the person who is a director has got an interest, say developed in July, then he can make the disclosure of interest in July itself, and this disclosure shall be holding for the whole financial year. He will not be required to make a disclosure at every board of directors meeting, but if such an interest is continuing even in the next financial year, then he has to make a fresh notice of the disclosure in the March month. Such renewal notice should also be given to the board, and the director should take all the reasonable steps to ensure that it is brought up and read at the first meeting of the board after it is given. This section does not restrict the director to have any interest or concern in any contract arrangements with the company, which just means that a director could be interested in any of the contracts, but the disclosure of the same is necessary. It does not abstain or restrict a director not to have an interest in the contracts. Now, where a contract or arrangement is entered between two companies and one or more directors of the company holds not more than 2% of the paid up share capital in the other company, this section shall not apply. So, the restriction on the quantum of interest is 2%. In case anything more than 2% of the paid up share capital is held by the director in mutually two companies, then such an interest has to be disclosed. Otherwise, it is not necessary for a disclosure. Say if only 1% shares of the paid up capital are held by a director who is also a director in another company, then the disclosure shall not be required. With this, we are concluding our today's session. In this session today, we had discussed about section 284 regarding removal of directors. We also discussed section 299 regarding interest of directors. Also, we discussed regarding section 299, 291, 292 and 93 regarding various situations in which the directors could exercise their powers, whether general powers or with restriction or by sanction of the company in its general meeting. I hope you enjoyed today's session. Thank you.